I'm trying to get there, sir.
There's no eating in the. Good evening, everybody. This is a regular meeting of the Guam Public Utilities Commission, July 30th, 2026, 6:30 p.m. All commissioners are present. First order of business is approval of the minutes of the June 25th, 2026 regular meeting.
Chairman, I move to approve the minutes as a technical correction.
Thank you, Mike.
Second.
Thank you, Pete. All in favor, say aye.
Aye.
Motion carries unanimously. Next item, GPA docket number 2610, petition of the Guam Power Authority to amend the Upidu Power Plant Energy Conversion Agreement to permit GPA to pay for additional testing. We have a legal counsel report and a proposed order. Mr. Pangolina, do you have a comment?
I do. Thank you, Mr. Chairman. I'm going to have to recuse on the next two docket items, the GPA docket item and also GWA. The GPA item involves Guam Upidu Power, which is a client of my law firm. GWA matter involves GWA, which is also a client of my law firm in family litigation. So I won't be able to participate in the next two docket items.
Thank you, Mike. Okay, Anthony?
Thank you, Mr. Chair, and just for the record, so we do have Teresa Rojas, who's representing GPA today on Zoom for this particular meeting. We have representing Busan, I believe it's attorney Michael Gatewood and attorney Regan Camacho, representing the GUP. We have attorney Rodney Jacobs appearing via Zoom. Now, once again, this particular petition, which was initially heard on May the 7th and then again on May the 21st, concerns GPA's request that the PUC approve amendment number 2, the third amendment in the state energy conversion agreement, or ECA. That it has responsibility to power, which amends Article 3.2.2 of the ECA by adding more or less the following language. Quote, and for the additional testing hours for the 75-day period from midnight on October the 1st, 2025 to midnight on December the 14th, 2025, GPA shall pay up to sum of $6.1 million. Or specifically, $6,148,441. So that's and GPA plans on funding this $6.1 million amount through the levelized energy adjustment clause for the Act. Now, so that's the language, the existing language of the ECA that GPA would like to add. Now, since the May 21st meeting, PUC instructed me to issue a scheduling order for motions to convene. And on June 30th, I did so. And, excuse me, on May 29th, I issued a scheduling order for motions to intervene. Both Busan and GUP filed their respective motions to intervene. GPA had the opportunity to respond to them. And I issued my order on June 30th, 2026, pursuant to rules of practice and procedure. Basically, finding that Busan and GUP had interest and grounds to intervene in this proceeding. Granted, Busan and GUP's motions to intervene, issued a scheduling order and issued a schedule for Busan and GUP to file their respective responses in accordance with GPA's contract review protocol to GPA's petition. And I also informed them that we would hear this matter today, June 30, 2026. Now, on July the 9th, both Busan and GUP filed, on July the 17th, both Busan and GUP filed their responses, or Busan filed its response opposing the petition, and GUP filed its response supporting the petition. On on July the 17th, on July the 24th, GPA filed its reply to USON's response, and GPA filed a non-opposition to GUP's response supporting the petition. So in a nutshell, of course, USON is opposing the petition, GUP is supporting the petition, or GUP and GPA is supporting the petition. Now, in terms of the contract review protocol, USON's one of the main arguments is that the GPA petition is an after-the-fact ratification that required prior PUC approval or showing of extraordinary cause under the contract review protocol. Now, the PUC has previously approved the ECA and amendment number 1, hence GPA is compliant with the protocol because it is requesting the PUC's approval prior to entering into ECA amendment number 2. Additionally, amendment number 2 is based on the existing framework of the ECA and amendment number 1, which PUC has previously approved. Further, amendment number 1 requires GPA to pay the costs associated with testing and for any energy produced from testing in accordance with Schedule 3 of the ECA. Here, in this matter, amendment number 2 continues the language of amendment number 1, inclusive of using Schedule 3 of the ECA to determine the cost of the energy provided during the testing. And they also add the amount of $6.1 million as the cost of the energy GPA received from testing during the 75-day period from October the 1st to December the 14th of 2025. Now, additionally, either GPA or GUP would know the actual costs of the test energy provided during the 75-day period until after, basically, the test energy was provided. In amendment number 1, PUC authorized GPA to expend the amount of $4.9 million for the test energy GPA received for that amendment. GPA, what did come out in the filings, in particular USON's filing, was that GPA only expended $3.8 million and 1.07 remains of that $4.9 million authorization. Now that the test energy has been provided, the benefit that we have is there's a firm discernible cost for the PUC to review. Further, ECA Schedule 3 utilizes equations for fixed and variable costs to determine the amount GPA will pay GUP for test energy, and the variable costs really are been unknown until the test energy is actually supplied, as was the case here. Finally, in terms of contract review protocol, even if we were to assume, arguendo, that GPA should make an extraordinary cause, show extraordinary cause, there are sufficient facts to meet that threshold if applied. Amendment number 1 covers the test energy period from May 30th to September 6th of 2025. GPA and GUP anticipated that the COD would be achieved by September 30th of 2026. However, on September the 3rd, 2025, it was GUP who notified GPA that the COD must be extended because of the repairs needed by one of the plant's 3 gas turbine generators, which extended the COD and the test energy period to December the 25th, 2025. Hence, extraordinary cause exists if required because but for the gas turbine repairs, the extension of the test energy period and amendment number 2 would be unnecessary. So basically, I found that GPA's petition is timely under GPA's contract review protocol because GPA is seeking PUC's approval prior to entering into amendment number 2, and because GPA now has the actual cost of the test energy provided for the 75-day period pursuant to Schedule 3 of the ECA. Now, so I reviewed the costs the $6.1 million cost of amendment number 2, I found that it should be corrected to 5.07 million to be reasonable. So, in essence, amendment number 2 is calculated using the same formulas for FOMAC and GOMAC as we used in amendment number 1. And using those equations in Schedule 3, GPA and GUP both conclude that the FOMAC for the 75-day period is 4.1 million, and the GOMAC for that period is about 209,000. The FOMAC, I give the equations where they both found that. However, when I did the math, and using that equation cited here, I found the product of that equation to be 4,691,691,012 which is $122 less than the FOMAC agreed upon by GPA and GUP. I also looked at the equation for the GOMAC, and I found that basically that amount was correct. So using the corrected FOMAC and the GOMAC, I found that those equations result in about a $4.3 million cost. Now the remaining part, this lump sum $6.1 million amount, is a $1.8 million payment to Siemens TA. And of course, this is the amount for direct costs consisting of additional commissioned field service specialists. And they originally wanted 1.9 million. There's about a 372K difference between Siemens' 1.9 million claim and the 1.8 million GPA. And the reason for this difference is the total claim by Siemens DA is for a 92-day period instead of the 75-day period set forth in amendment number 2. However, looking at those days and doing the math, 75 days out of the 92-day period is 82%, not 83%. Hence, the correct apportionment of the Siemens TA claim should be $1,795,679,000, which is about 21K less than the $1.8 million amount that was based on the 83% portion. Now, where does this leave us? Well, based on the corrected $4.1 million FOMAC, the 209K FOMAC, and the corrected 1.7 million for the Siemens DA claim, the total amount of $6,126,431 is the reasonable amount for the lump sum payment required by ECA and the 2. Because the PUC previously authorized GPA to expend 4.9 million and 1.07 remains for that amount, I believe that must be applied to this amount, further reducing this amount to 5.07. Now, Tucson also argued that the corrected $6.1 million cost of ECA Amendment 2 is not reasonable because it was based on a settlement and not the actual cost. It has no merit, or this argument has no merit. Basically, since the PUC approved ECA Amendment number 1 on May 29th of 2025, ECA Article 2 states in relevant part, Section 7.1 and Schedule notwithstanding, prior to the commercial operational date, that's COD, GPA will make all reasonable efforts to accept all the energy generated and shall pay for such energy delivered to GPA during testing and commissioning on terms mutually agreed upon by the parties. That's how it reads. Hence, assuming arguendo that the 6.1 million test energy amount was in fact just a settlement amount they made up, the ECA allows GPA and GUP to agree on said amount so long as it provides a benefit to the ratepayers. Here, GPA submitted, we don't have to go with that because GPA submitted the actual costs incurred for the 75-day period covered by ECA Amendment Number 2. And this information actually validates the amount, albeit at the correct amount of 6.1 billion. So they didn't just come up with this number out of thin air. They based it on actual figures, which proved to be mostly accurate. Now, Doosan's opposition merely states that it had previously agreed to FOMAC and FOMAC amounts in Amendment Number 1, because it did not believe GPA would impose liquidated damages for the delayed COD. Additionally, Doosan provided correspondence between GPA and GUP, which indicates that they were discussing the costs that would be the basis of ECA Amendment Number 2, to include the 1,208 hour / unit amount that would be used in the FOMAC equation, and the 0.0020 per kilowatt hour that we use in the FOMAC equation, and also the amount claimed by Siemens PA. However, this by itself does not show how, if at all, the cost data provided by GPA is inaccurate, unreasonable, or that the test energy GPA received was not a benefit to the ratepayers. Therefore, Doosan's argument that this corrected $6.1 million amount is not reasonable because it was based on a settlement, not the actual cost, has no merit as well. So, with that, it's in the supplemental report I found that the corrected 6.1 million test energy costs in ECA Amendment Number 2 is reasonable, prudent, and necessary under GPA's contract review protocol. It's my recommendation that the PUC authorize GPA to apply the amount of 1.07 million remaining from the PUC's authorization for ECA Amendment 1 to cover the costs of ECA Amendment Number 2. I also recommend that the PUC grant GPA's petition to amend the new power plant conversion agreement to permit GPA to pay for additional test energy in the amount of 5.07 million for that amendment. And I did submit a proposed order for consideration of the issues.
Thanks, Anthony. Are we going to be receiving any comments from?
Yes, we can. So just like our usual thing, we could go to GPA, and then we would have to go to, by order of their interference appearance, Doosan, and GUP.
Okay. Go ahead, please.
Thank you, Mr. Chair. Good evening. Thank you to ALJ Camacho for the introductions. If I may, again, I'm appearing on behalf of Guam Power Authority this evening. The commission may, of course, everybody's familiar with Attorney Watershed. She has served GPA for the last 2 years. She served the utility well, but she's recently made the hard decision to depart the utility. So at present, there is a vacancy with the GPA council position. So until that vacancy is filled, I will be serving in a very temporary and perhaps maybe even a limited capacity as GPA's council when needed. And so that need has arisen this evening, so I'm appearing before the commission today. I would also like to seek the commission's indulgence to introduce another member of the GPA team who's online. It's Attorney Matt Morrison. Attorney Morrison has actually been serving as GPA's environmental consultant. As the board is familiar, the Ukudu project is something that came about because of the order and passage of the federal consent decree. And so Attorney Morrison actually has appeared before the PUC when the federal consent decree was entered. He appeared with GPA as the environmental consultant, and he's actually been serving GPA since that time. So he's extremely familiar with this project. He's familiar with all of the documents and he's extremely familiar with this project. He's familiar with all of the contracting documents. And as the ALJ stated in its supplemental PUC council report, the version that's in effect today is actually the third amended and restated ECA. So it's been through a number of revisions. The ECA has been through a number of revisions, since it was initially entered back in November of 2019. And we discussed amendment number 1 to the third amended and restated ECA, and now before the commission, GPA is seeking approval of amendment number 2. So I am seeking the commission's indulgence that if there are specific facts as to this agreement, that we have our environmental consultant, Attorney Matt Morrison, be able to respond. Another fact is Mary Ann officially departed the utility on the weekend. So I am now serving in the 4th day as acting counsel. So for those reasons, I do again seek the commission's indulgence. But there's a question that can be better answered by Mr. Morrison. Okay. Getting to what's at issue this evening, GPA is on the record for saying that we wholly support, of course, the recommendations made by the ALJ. First, we support the ALJ findings in its June 30th order that the parties who were seeking to intervene here, the parties who have sought to intervene are able to appear, but only able to appear in a limited capacity. They're only able to address whether or not this issue and the approval of amendment number 2 is in accordance with GPA's contract review protocol and nothing more. The parties have, of course, raised a lot of collateral issues, in particular Tucson, and a lot of that has been broader contractual disputes, which the ALJ has already correctly pointed out and adopted in its June 30th order that are not properly before PUC. The PUC, of course, knows its mission, and the PUC's mission is to set just and reasonable rates. And broader contractual disputes isn't properly before this body. And so we thank the ALJ for putting that on the record, that the appearance of both Tucson and GUP this evening are limited. Getting to the approval of amendment number 2, and I guess some of the arguments on why it's not reasonable, just, and prudent. So amendment number 2 seeks, it's a prospective approval. Amendment number 1 allowed GPA to purchase test energy and allowed the parties to negotiate that. And to be absolutely clear, the parties to the ECA, the parties remain to be Guam Power Authority and Guam PUC Power. Tucson is not a party to that contract. Tucson is not an authorized seller of power to GPA, and that needs to be made very clear. The only parties to that agreement, the parties who negotiated that agreement, are GUP and GPA. And the framework for receiving the test energy and the pricing was already approved and put before the PUC in May of 2025, and that was approved under docket 25-12. And the ALJ has accurately reported that history in his supplemental report, and that's on the record before the commission. And he's absolutely correct. He said this evening to the commissioners that the prices didn't come out of thin air, and that's what makes it just and reasonable. When GPA was purchasing test energy, they knew how much it was going to cost. We just didn't know how much time we would need to purchase that test energy for. And that's why the heavy words like ratification are really being put before this commission to confuse and mislead the commission, and that's not the case. If there wasn't a framework in place and if there wasn't a price in place, this would be an entirely different discussion, but that is not the case this evening. Amendment number 1 and I believe it's the attachment or, sorry, the document attached to amendment number 1, which has all the pricing, which has the fixed and variable rates, and that's what we're referring to. That's where we're able to come to the 6.1. And GUP and GPA were able to keep and continue that agreement. And so what's really important under the contract review protocol is that if pricing terms are amended, we're supposed to come back to the PUC. But here, there are no pricing terms were amended. And I know Doosan included in some of its filings, there was a statement that said, what happened is really the Power Authority decided to take the power now and leave the price for later. That's not accurate, and that's not supported in the record at all. The pricing terms existed and they were approved, but what's really happening is Doosan desires, or they desired then, and they still desire today, to amend those pricing terms. And that's not what we're seeking the PUC's approval on. Amendment number 2, again, is seeking approval on the pricing terms that have been negotiated and approved by GUP and GPA and that are firmly in the record. And so, for these reasons, we thank the ALJ for his support. I also want to point out the fact that the ALJ heavily scrutinized and reviewed the pricing terms that existed. If this were a ratification, this would be an approval of a past event, something that already occurred. GPA has not paid Guam PUC Power for the test energy it has received. There's been no payment. This is not a ratification to that effect. The ALJ has performed his due diligence. The amount that we are seeking is now going to be reduced by an approximately $21,000 to $22,000, and that's because of the oversight and scrutiny exercised by the PUC. So we're seeking the approval of the amount of test energy, of course, that was consumed by the power utility. So that scrutiny, that oversight is all evident and before the commission today. And GPA, although the amount that we requested be approved is now being reduced by approximately 21 or 22,000, we have no objection to the amount. We accept the ALJ's review and we ask the commission to approve amendment number 2. And I recognize that the ALJ has a few more details. We talk about the approval of amendment number 1 and the 4.9 million that was initially authorized, and then the excess of the 4.9 million, GPA had only paid for 3.8 million in test energy, so there remains roughly 1 million. And so the 1 million will be applied to the 6 million, and then the total amount that GPA is being authorized to pay, I believe, is $5,078,451. And we have no objection. And so all of those specifics and details are included in the ALJ's recommendation. So with that, I conclude, and if there's any other questions, we're happy to answer that.
Would Mr. Morrison be contributing anything at all?
Sure, yes, thank you. Commissioners, thank you. We really do appreciate the opportunity to speak with you this evening. I will be brief because I do not have much to add to the excellent remarks already made by the ALJ and Ms. Rojas. As she explained, sole issue before you today is whether you should approve amendment number 2 to the ECA based on GPA's contract protocol. And specifically, paragraph 7 of that protocol requires you to decide just one thing, whether the rates and terms in Amendment 2 are reasonable, prudent, necessary in the public interest. Nothing more than that, nothing less. And we know from your order of June 30th, that's all we should delve into this evening because it specifically limits DUP's intervention on that issue. But it's important to point out that's not what DUP already did in its opposition to the proposed amendment. It exceeded your important limitation and effectively asked the Commission to adjudicate whether the proposed payment adequately compensates DUP's self-assessed costs. That's inappropriate, we feel. We feel like it's already in violation of the Commission's order. So, as a threshold matter, we're asking the Commission to enforce that important limitation in this proceeding. This is not an adjudication of DUP's government claim, nor is it a forum for DUP's EPC contract dispute. And it's not even an inquiry into a variety of other issues DUP has raised in this matter. All of those matters, importantly, are pending in other tribunals. The Government Claims Act process, the arbitration in Los Angeles, Superior Court of Guam, and what we're concerned about, among other things, is that any statements that we might make in this proceeding could be used by DUP against us in those separate claims processes or arbitrations. So for that additional reason, it would be inappropriate to address them. Before I wrap up just an introductory remarks, I want to provide just a very quick recap of a couple of important points of what brought us here today. And the ALJ did a great job with some of this. But I'll go back really quickly to March of 2025, when the Okudu facility was still undergoing testing prior to reaching commercial operation. The problem GPA encountered was power generation shortages, particularly after the solar production dropped in the evening and while older GPA units were difficult to maintain. So it got bad enough that GPA sought help from Guam Okudu. Unfortunately, GUP agreed to help, but understandably it indicated that the dispatch of additional power would likely create additional costs that needed to be tracked and reimbursed. We agreed, and in May of 2025, this commission did approve Amendment 1 to the ECA, and as we've covered, that allowed GPA to purchase additional testing power from GUP during that pre-commissioning period, and it also modified the ECA to allow us to pay, or to require us to pay for such energy, and that was approved by the commission. But then, right at that point, the project began to encounter further delays. After the initial May to September testing period, the steam turbine generator failed in June of 2025. One of the gas turbine generators was also damaged a few months later, in September. So all of that contributed to a further delay in reaching the commercial operation date, or COD, that was in the ECA, delayed it from the end of September to the end of December. And that continued need for power during this phase led the parties, GUP and GPA, to draft up a second amendment. And that's the amendment we have in front of us tonight. And that amendment is important because it addresses the payment for test energy during this second period, October 1st through December 1st, end of December. Both of those periods provided the much needed power to GPA ratepayers, and both were drafted along nearly identical terms and methodologies. In fact, Amendment 2 simply implements what's already the existing commission-approved test energy framework that was already established by the parties in the PUC. It reflects the same amount, and so we're asking that the commission approve this second amendment. And lastly, in closing, to the extent DUP has views on the reasonableness of this amendment to the ECA, we ask that you please keep in perspective the weight that should be given to its views. As Ms. Rojas said, DUP has no contractual privity with Guam Power Authority, either under the ECA, the EPC, or otherwise. It's not a party to that ECA, which is the operative agreement here. In fact, the interest it derives is from a separate $11.3 million government claim, a claim that is likely to proceed later this year, regardless of what we do this evening regarding Amendment 2. So respectfully, we ask the Commission to grant GPA's petition and approve Amendment number 2. Thanks very much, and appreciate the opportunity to address you this evening.
Thank you, Mr. Morrison. You want to-
Mr. Chairman?
Yeah.
So just a quick explanation. So we have the ECA, and that is the energy conversion agreement between GPA and GUP. The EPC that he's referring to, that's the contract between GUP and DUSON. Okay, so I didn't mention that earlier, but that's a good idea. I just want to clarify.
And what is Doosan to GUP?
Doosan is the,
Subcontract.
yeah, so they were contracted by GUP to construct the plant.
Who was contracted?
Doosan,
Doosan was contracted by GUP
to construct the plant.
to construct the plant.
And their contract is the EPC. Yeah, but that's not before us, and has never been before us.
So, yeah, because I still get a little, I'm sorry, I need a chalkboard to help explain this. So,
Doosan is up next, so you have the opportunity to
well,
ask them.
before they come up, you
Okay,
know, if you don't mind, just so I can get it straight in my head. Who did GPA contract to build Ukudu? I'm gonna go back to the basic, GUP.
Guam PUC Power.
Okay, so and then GUP in turn contracted
Doosan to construct the plant. Yes, correct.
to help build the plant that they were awarded by GPA.
That's correct.
Okay.
So the first agreement is the ECA, and the second agreement is the ETC. It can be a little.
ECA is
Energy
between,
conversion agreement.
ECA is between,
GPA and GUP.
and so going forward for the next 25 years, we will be dealing with GUP, okay? Okay, so pardon the expression, so the beef is between GUP and Doosan,
That's correct.
okay?
They do make allegations, however, in their pleadings that,
Yeah,
that GPA is also involved, but like I said, believe, this is my report, I do address their objections, but they are next, and commissioners are gonna have the opportunity to question them directly.
so just one other question, so while throughout this time, though, GPA personnel were dealing both with GUP as well as Doosan people, because Doosan people were on the job, right? If there were any issues during construction or whatever, who did GPA go to? Did they go to GUP? Did they go to Doosan? Did they go to both? You know, because they were the prime subcontractor.
Jennifer will answer that. Jennifer will give us.
Okay.
Thank you, Jennifer.
You know, just to know what was the relationship.
Good evening, Commissioners. Jennifer Salon, Assistant GM for Operations at GPA. So because it's construction, we do have people dealing with the construction people
Right.
to do the evaluation on all of the requirements. So we didn't review everything. Certain things that we were intimately involved with was the interconnection, which was the power line connection to the plant, as well as the pipeline. We did have questions with our consultant, which was Stanley Consultants, to review some of the things during the construction and through the testing. So yes, we would speak to Doosan in that regard because they are the contractors in construction, but most of the formal all the formal documentation went to GUP.
Thank you for that.
All right, Mr. Chair, there be no further questions from GPA. Basically, I'd like, I believe Doosan is represented by 3 attorneys. And so we do have Attorney Gatewood, Attorney Levin Camacho, and I believe we also have Attorney Phil Torres, who's online. So Doosan, you do have the floor. Thank you.
Thank you very much. I guess I'm the lucky one to go first for Doosan. Thank you guys very much, the commissioners and Mr. Camacho, for letting us, intervene and kind of help. We also recognize, as GPA has pointed out, and Mr. Camacho, that this matters, directly limited to, the contract amendment. And we're not gonna discuss the, contractual disputes or the government claims, and we're hoping, and we think it's prudent that that language is put in any order that the PUC issues tonight. Because it should be clear that the determination that happens tonight doesn't resolve any claims or compensation that's owed to Doosan or any contractual rights. So we're hoping that that can be included in any order that's issued tonight, and we can submit, proposed language, after the hearing is completed. So that's one of the things that we're hoping for. And just for the commissioners to understand, Doosan doesn't want to be here. They don't want to bring this to the commission's attention. They just were left with no options. I've tried numerous times to talk to GPA to try to resolve this. I've emailed them, I just never had the opportunity to try to resolve this. So they never wanted to be here. And then I think the reason why it should be denied is because as you can see, there's so many outstanding issues. There's government claims, there's contract disputes, there's going to be arbitration. And I just think it's prudent that the commissioners look at that and say, well, this is not fully resolved. Can GPA and CCU, can you guys figure all this out and get it resolved? Because it's ultimately, at the end of the day, it's going to affect ratepayers. And that's something that we were trying to avoid. We just never got the opportunity to do so. And, lastly, for me, before leaving Camacho, talks is, I think the differences between the First Amendment and the Second Amendment are very clear. The First Amendment is, for sure, it's testing hours. And Doosan was fully on board. They were involved in what happened. And then the second, September, October, November not testing hours, it was actually full on grid support. So I think it's really, really hard to compare those, circumstances. I think they're completely different, and I'm hoping the commissioners agree. And I just really hope that we can put, the language in the order for sure, limiting the, what this matter is. And I'll let Mr. Camacho, kind of talk about some of the issues he's going to bring up, but I'd be happy to answer you, any questions the commissioners have.
Thank you. I guess I'll start by just saying factually, I'm not sure if Ms. Flores Brooks, the question might have been, who was actually providing the power? And we've heard a lot about contracts and contractual relationships and sub and prime. And I think that during the time that as that issue, I don't believe GPA would dispute or GUP would dispute that it was Doosan who was running and operating and providing the power during this period. GUP did not take over until late December. I really wanted to focus primarily on the protocol and Rule 7 in particular, which requires the CCU to have a resolution and to adopt and to then submit the documentation showing that it's thought about its figures and what it's proposed to the commission. I noticed that GPA Council said that they support the petition, but what really is before the commission today is the ALJ's order. And as the ALJ has gone through, there were several corrections that needed to be made to the figures that were provided by the CCU and by GPA. To start with, this is a lump sum payment that is being requested. It was only through the RFI that was submitted by the ALJ that GPA was required to provide a breakdown of how it came up with the $6,148,400. And noticed that their math was incorrect.
Mr. Camacho, you were broken for just a little bit. If you could go back, I want to say we didn't catch the last 30 seconds of your last statement. Thank you.
I apologize. So I have a little bit of a spotty connection here, but just going through that, there were several corrections that needed to be made to GPA's figure by the ALJ here. The rate multiplication was wrong by the hours. The technical assistant basically had to reverse engineer how they arrived at that figure. So we already are talking about a different number. So instead of the $6,148,441, the corrected amount before we intervened was $6,126,431, which is about a $22,000 difference. particular an October 1st letter from GPA. There was another $1 million, $1,070,000 that was unaccounted for the first tank. So again, there's another correction that needs to be made, reducing now the amount from $6,148,000 to $5,078,451. So I guess I just would ask the petition for GPA, or is it really GPA's obligation and responsibility to do their homework first and then to have the CCU adopt a resolution that is accurate and thorough and correct, and then to provide it to the commission for consideration and approval? I do want to make I know that the ALJ, there was a lot of numbers and a lot of discrepancies, but in the order itself, it seemed to be a little bit of an error. He used in the ordering provisions, he used a $6,126,431 figure, which is accurate. But when he reduced it by the $1 million figure, he didn't adjust for the $22,000. So there's a little bit of the correct amount should actually be $5,056,431, not $5,078,451. So if you are considering this order, just note that it is not currently internally consistent with the math. Thank you.
Thank you, Lee. I noticed that too, so I was gonna tell Anthony maybe another thing. Is Mr. Torres gonna make comments also? Bill?
Attorney Torres?
I'm not sure if he was prepared to make a statement, but we'd be happy to answer any questions the commissioners have.
Okay. So, if the commissioners have any questions they'd like to ask you, so I believe attorneys Camacho and David will respond.
Any questions?
So, what is the beef? I'm still trying to.
They would like the direct payment themselves. They would like the direct payment themselves,
What do you mean? Oh, the money?
rather than to GUP. Is that what it is?
Is that,
That's part of it.
If I may, I think Doosan's just not being fully compensated for everything that they've done on the project, and I think that's where we're at. So the amendment, they don't agree with it because it doesn't make them whole. They also have other claims, that are outstanding, and that's why I think it's really premature to get this thing through with everything else that's outstanding.
so the way the order is written right now, if we were to approve it, or
It
in
would be-
principle, whatever.
I'd have to double check the number, but I believe he
Yeah,
might
other
be
than that,
correct.
yeah.
So there's a further, there's a
So-
further 22K reduction to that 5.07.
So, the way the order is written approximately, if we approve it, GPA would pay,
GUP.
but in the past, GPA has paid.
Well, for
Yes,
amendment,
no,
for amendment number.
there was comments
yeah,
earlier
yeah,
that
for
we
amendment
need
number
direct
one,
payments
Then
too.
I don't get that.
Yeah, GPA was making direct, according to the record, and the filings, I believe GPA admitted this, that they were pursuant to GUP's request, they were paying Doosan directly, for the amendment, number one points.
GUP gave the green light on that.
Yes, So where is GUP now with this order?
We're gonna find out in just a few minutes.
Yeah, they're,
Oh.
Ronnie
They're
Jacob
up
is
next.
next.
Oh, okay, thank you.
But I will
Like I
correct,
said, this is
that.
clear as mud.
But they are making a new request today. They're requesting that language to the proposed order. This order solely is on the contract review protocol. You're not ruling, or this is not ruling, or it's not a ruling on the government claim,
Correct.
or a possible contract dispute with GUP or GPA.
which is reasonable.
Yeah, well, I haven't seen the language yet, but I believe, I've crafted, or working with, Mr. Gatewood and, Mr. Camacho, we could probably craft some language that, would be acceptable to, parties. Achieve that. If the desire, so.
Do you have another comment, Mr. Gatewood?
Yes, sir. I have some suggested language and I could submit it. And I could submit it for everybody to take a look at. It's really not that much, but if we have the opportunity, I would love to. If the commissioners are going to approve it, we're still hoping you deny it and send it back to GPA and the CCU to, figure everything out. But if the commissioners do approve it, we do have some language in any order that's given that we would like included. Just if you could let me know how you would like it provided, sir, Mr. Camacho.
Okay, well, if you provide anything, it would be filing to all the parties. Okay, so they could all have a look at it. Okay, without being day of vacation. Okay.
Thank you.
Any other questions for Lisa?
No?
Okay.
So,
So the final party here is GUP. Once again, it's just by their order of appearance, you sign it and then update. So I believe we have Attorney Rodney Jacob, is that correct?
That's correct. Can you hear me okay?
Yes,
You can.
the floor is yours.
All right, great. I'm here with Guam PUC Power's in-house counsel, Patrick Sherman. So that who else is on the screen with me. We really don't go by GUP, it's GUP, stands for Guam PUC Power. Some of the nomenclature is a little, can be confusing. So the commissioner's questions about kind of sorting out the agreements was really just spot on because it even took us lawyers a little bit of time to figure it out. And basically, the commission heard loud and clear tonight that there's only one contract for the sale of energy, and that's between GUP and GPA. It would be unlawful to hold otherwise. This amendment follows years and years and years of planning, regulatory approvals and oversights, and legislative involvement, both with getting the land and approving the land lease. And I'm sure this commission knows that history. We're talking about the last amendment last year, which clearly states, for the reason you heard, that GPA is obligated to buy all the test energy through commercial operation date. The reason we're here is because Doosan delivered defective generators during last summer, and the COD, the commercial operation date, was delayed until late December. The commission also probably knows that Doosan had to pay millions and millions of dollars in liquidated damages for what it failed to do under the agreements that were approved at all levels, including the energy conversion agreement. So we're here at the tail end of this, having the plant constructed at enormous cost, requiring GUP to put together a lending consortium to pay for that construction. And guess who it paid? Doosan, DUP. And there is no doubt, no question, no matter of law, that the only party that can sell energy, that can produce energy, is my client, GUP. It did just that, and it sold the test energy to GPA. And it did so under a contract approved by the CCU and this body last year. Doosan doesn't make an argument that that contractual language is any way invalid. And I'll read it to you. It says, Section 7.1 and Schedule 4 notwithstanding, prior to the commercial operation date, GPA will make all reasonable efforts to accept all the energy generated and shall pay for such energy delivered to GPA during testing and commissioning on terms mutually agreeable. That language was approved, and the only reason we're here is to get approval for the cost of that second set of testing energy. So we fully endorse, GUP fully endorsed the ALJ report. We really encourage this commission to approve it. I'm happy to answer any questions that the commission has. All the collateral fights that Doosan wants to bring before this commission to hip chuck and otherwise extremely important conclusion to a very difficult saga for GPA and our community, that is getting the Ukadu power plant built under very difficult circumstances and under, by the way, United States District Court consent decree and at great cost. And so there is no obstacle for this commission to approve the petition, any disputes, and I assure the commission there are plenty between GUP and Doosan, will get resolved in the manner in which the EPC, which is the engineering and procurement contract, which is between GUP and Doosan, calls for, which is arbitration under the AAA rules in Los Angeles. That's part of a very carefully put together fabric, which has governed the construction of this plant and the delivery of power now successfully to our community. So if there are any questions, I'm happy to take them. I want to say thank you to the PUC and to GPA for all their efforts in hearing us. We do appreciate it. In conclusion, we support the ALJ's very carefully reasoned report and order. Thank you.
Thank you, Mr. Jacobs. Any questions for Mr. Go ahead, George.
On a going forward basis, you know, like, let's just say, another rotor breaks down, you know, on a going forward basis, although Doosan in effect built the plant that was contracted by GUP, but going forward now, who will GPA talk to, you know, if something breaks down? Is it going to be GUP or is it going to be Doosan?
Commissioner Flores Brooks, thanks for that great question. The only contract that GPA has is with my client GUP. So those would be matters between GPA and GUP. If there are disputes related to those, that would be between GUP and Doosan. And importantly, with respect to this ECA amendment, the commission probably read this in our submission, but Doosan has a back-to-back agreement with us for the May 2025 amendment that, number one, provided for payments to Doosan as an accommodation, but very clearly, and I'm reading it, and Doosan signed this, nothing herein shall be construed as creating a contractual obligation of payment from GPA to DUP or from GUP to DUP in respect to the additional testing hours. So it's absolutely clear there is no contractual relationship between Doosan and GPA. That contractual relationship rests with GPA and GUP. All disputes have an important, carefully negotiated track for dispute resolution between my client and Doosan, and it's not this forum. If they have a problem with the funding that we made, and they're going to have a lot of explaining to do why they decided to breach that agreement by coming here for dispute resolution, they can do that in front of the AAA. We don't need any language to suggest that this commission had authority over our disputes, because it just doesn't. This commission's sole duty is to interpret the contract review protocols in relation to an already approved obligation that GPA has, just as the ALJ said. So hopefully that answered your question, Commissioner.
Not quite, I apologize, I'm a little bit slow. So just going back, Jennifer, let's say, if tomorrow something breaks down, then you're going to go directly to GUP to resolve it, right?
Yes, our contract is only,
And who GUP goes to is, that's the truth. Okay, good. All right, thank you for that.
Excuse me. This is Phil Torres. I wasn't able to get my audio to work or my video to work. I just wanted to make a few comments when I had the opportunity to do so earlier. That's okay. So the issue here is whether the commission is going to approve or deny the amendment as proposed. The memo has not been redrafted in any way. And I think the question becomes, we're arguing about the protocol and the contract. There's no issue about the contracts because they speak for themselves. GUP has a contract with GPA. They do not have a contract with the subcontractor. Subcontractor has it with the prime. However, the prime did not take over until the end of December. He was not in control of the plant or the production of any energy. So when energy was being provided to GPA in the summer of 2025, it was coming from Doosan. When energy was needed because we were not going to deliver on time, it was coming from Doosan. The correspondence between GPA was with Doosan. There was no advance agreement on what those dollars were going to be. There was an agreement because because the rules and regulations say that you're supposed to have an agreement ahead of time for the purchase of energy. There was none for the second batch of energy. And that's why we're here, and that's why we have a dispute on the amount. And the greater reason we have the dispute on the amount was because Doosan was never allowed to be involved in the discussions over this payment. They have laid out exactly what the cost of that energy was, yet the agreement is between GPA and GUP. The commission knows that there's an issue here. To approve this amendment, instead of sending it back and say, give us exact numbers, whether you're going to say they're lower or greater. When we are producing energy, we have to have insurance. That insurance was in place for the summer. It wasn't in place for December. October, November, December, it was anticipated. Doosan could have said, because it was in charge of the plant, we're not going to provide any power. We're just going to do our testing and see if we can deliver this as soon as possible. But instead, they did agree to do so. But they didn't agree on what that dollar amount is. So this is an after fact agreement in which they were not allowed to participate. And that's the problem here. And that's why Doosan has come to the commission. I just wanted to point that out.
Thank you, Mr. Torres. Tracy, go ahead.
Thank you, Mr. Chair. So I just asked the commission to hear a few more comments from GPA following, I guess, the remarks made by Doosan's councils and GPA's council. So one, we've heard twice by counsel from Doosan that the plant wasn't handed over until December 2025. Regardless of that comment, and I will not couch it as a fact because that still needs to be verified, regardless of that comment, there was no privity or there was no direct contractual relationship between GPA and Doosan, as if, handing over the plant created some kind of magical contract. It did not exist. The ALJ has correctly pointed out and included in the supplemental report that there was a contract in place which took effect on October 31st, 2019. And that is the contract in place between GPA and GUP, Guam PUC Power. I also wanted to make a comment on the request from Doosan's council to add language that this petition doesn't resolve, the contractual disputes. I think that the ALJ's language and what he's included on page 5 of his June 30th order is inherent, that the PUC is not a forum to litigate broader contractual disputes, and I think that can end there. To give the parties an opportunity to come back, I think is allowing Doosan to reach and use this forum improperly. Using this forum to take, I think it's allowing, if the commission decides to grant that request, that would allow Doosan to use this forum improperly to take advantage of the PUC to support the relief that it's seeking in other forums, the Government Claims Act, litigation that's ongoing in the Superior Court of Guam, FOIA, an arbitration proceeding that perhaps will begin with GUP and DC and Doosan. So we ask the commission to deny that request and leave the language as is. Again, it's inherent in the ALJ's June 30th order.
Thank you, Teresa.
Thank you, Mr. Chairman.
Rep, anything out there?
No, unless, just subject to your questions. So, a couple of issues. Okay, so number one, it's the order. Of course, it does need those technical amendments. Okay. The other issue is the commissioners want, and it wouldn't just be for use on. You have to give, I guess, a filing deadline if they wanted to add that limiting language, but that would be open to all the parties, not just. We could do that. That's up to you.
And what would that additional language do?
It would probably give Doosan more than any other parties, I guess, additional comfort that we're not adjudicating any of their government claims. The problem is, although they're quite expensive, like we even have a case, that's a case from the Superior Court. I don't know what the arbitration is going to do. I don't know if any of these issues, that's the problem we have. We're kind of flying blind with that. Because we don't know all of the issues that they have with each other. Okay?
Yeah.
So that's the issue. Nor are they verifiable, because I never have had a copy of the UPC that's never been before. So we are taking a little bit of a risk if we go that route, because we just don't know what claims they actually have, or they're actually litigating.
The extent of the language would be again, and just to kind of.
Well, it'd be something like, okay, so nothing, it would be the last sentence literally next to the, or second to last sentence next to the regulatory cost paragraph, would be something like that. Notwithstanding the foregoing, this order is limited to approving or denying the contract, or, number 2, and nothing more. Or something like that.
Basically, it would be staying in our neck.
Yeah, which I think is appropriate, yeah.
We could, if they're going to allow the parties to do that, or suggest language, like I said, we'd have to open it up to all the parties.
Sure, because everybody's involved, so let everybody be involved.
But then the body evolves into something else, but it's not meant for this commission was trying to evolve into something else. At the end of the day, we start listening to all, we have the ECA, which is before us right now, and that's the amendment. So that's the challenge that I have.
It might set a precedent, you know, correct?
Yes, and we also want to, one of the attorneys also made a comment earlier that we need to be careful also in terms of, it was our order that we gave them to go ahead and the green light to go ahead and get to buy the testing power. And so we're here now just to approve that final phase, which is the pricing, correct?
Well, no, there were two phases. So the initial one, I believe, was from June the 1st to September the 6th. And that's one where the previously authorized 4.9 million, those amendment is one. But the COD was not achieved in September. And then there was the second phase, if you will, for a period covered by amendment number 2, October 1 to December the 14th. And that's really what we're here for.
Yeah, so getting back to my original comment was, we need to address that was before us, I guess, which is that amendment.
That's right, amendment 2, that's the only thing.
And because and just and reasonable is part of our process. And so the contract was just and reasonable for your report, right, in terms of the dealings between GUP and GPA. But
That's correct, that's
So,
always reasonable and
and
necessary.
all the other issues that are, that have concerned us from, a couple of months back are now before other tribunals, I guess, that will.
Yes, to my knowledge, there's the FOIA case.
Right.
I believe, which we would, there's already that in the Superior Court. There is, as we well know, because they gave us a copy of the governing claim in the 21st hearing. So there is the governing claim, and as Mr. Jacob stated, there is an arbitration in Los Angeles between GDP and Houston. That's all I know for now. In this matter.
So if this, let's say, we move forward with this particular amendment because it's within our lane to approve this particular docket, or this particular order as written, and through other means, there's litigation that goes on between GUP and GUP and Doosan, and I guess that would be between those two, wouldn't be between GUP or Doosan and GPA.
I'm not, the issue I have is, like I said, the big, where I'm really flying behind as an attorney, I don't have that third contract, you don't have the EPC. So I don't know.
Because that's not what's before us today anyways.
No, it's not. So I don't know what the effect would be in the litigation between the GDP and Doosan. Doosan prevails, and
Yeah, in the event that Doosan prevails in any of those,
yeah.
does that pull GPA into, is the GPA liable for that?
Well, I don't really know, because in the EPC, GDP, Doosan contract, it would talk about who would be liable for what, but between those two parties.
Right.
So I don't, I can't really say without looking at the ECA and the EPC or liability. That's a different analysis, because the EPC is not before.
Yeah, right, I'm just wondering, like, beyond this particular $5 million or additional, let's say $6 million that we're discussing, is there potentially more to come later on down the road through this litigation, this process that we're going through? Should they prevail?
On GPA's behalf?
On GPA's behalf?
If they-
Would that be just between
If-
GUP and Doosan?
I know that with the government claim, so let's say that they prevail on the government claim against GPA, then yes, GPA would have additional costs to pay if they prevailed on the government claim. But that's only 11.3 million or something.
Yeah, because the original claim, or the original argument or request was for around $11 to $12 million, I think it was.
That's correct. I'm always, in top of my head, I want to say it's like 11,
11 something, 12,
something around there.
And then, and so we're agreeing to put together this $6 million to pay off the.
It's actually 5 million.
Or 5 million, 5 plus, right?
That's correct.
Minus the million that we have staff.
Yeah, no, that's just for that one period, and it's important to note that, it's undisputed, that we did get power between October 1st and, December 14th. And they haven't been paid for it yet. That's, you know.
My only concern is that if this gets drawn out into like some, beyond this order, if it gets drawn out and, without current legal counsel over at GPA, and then with the help of consultants and outside, could it rack up $6 million at the end of the day? And are they gonna end up paying more in legal fees and then somewhere down the road?
What's on the table is with the government claim, and it's that $11-12 million amount.
Right.
So it's currently on the table, so potentially.
Is that over and beyond the $6 million? Because this goes to them, correct? Or a portion of this will go to Tucson?
That's what they were indicating originally.
Yeah, maybe, but like I said, I don't have the EPC. I know that the prior, 4.9 million that was authorized, they were making direct payments to for a portion of that. But they didn't even reach the 4 point.
No, that was the
GP's request.
Correct.
Yeah.
Yeah,
They
GP authorized that.
can ultimately control that.
Yeah, so here, technically they can do the same thing. They agree, okay, hey, out of that 5 million, but 6 million, which we have in the extra million authorization for 1 million. They could do that again, but that would be between them.
Right.
Yeah. The sole issue is.
So if we move forward, because the matter really is about the ECA and amendment number 2. Right?
Yes.
And so, and obviously that was something that we put set in motion, so we should probably move in that direction. If we go in that direction, then, and we add the language, whatever you're gonna put the one sentence into, do they have, is there recourse later on their end to come back to GPA?
There might be. They have to pay 11.3 million on the government claim, or whatever that.
Oh, so that is between Tucson and GPA, or is it?
That's correct, the government claim is.
It's not GP?
The government claim is directly against GPA. It's for about that 11 to 12 million dollar amount.
Okay, so then there's recourse for them to get the difference.
That is correct.
Okay,
That's through the Government Claims Act, which we do not play a role.
right. Okay,
Out of our lane.
out of our, yeah.
Any comments, Joe?
With PUC not being informed to adjudicate these claims, whether you have the language in or not, you're still not informed.
That is correct. So with or without the language, we do not adjudicate government claims, nor do we adjudicate contractual disputes between non-government entities, and that's what GP and USON are.
I don't think in your present order that I'm reading, Anthony, there's any limitations on them for pursuing these other avenues at this point. And you don't have any limitations here of any substance at all that I can see.
No, I'm solely,
So,
it's just.
I don't know that we need any extra language at this point.
I'm just telling the PUC that you have that option. So desire.
And I would like to see it only just make sure that everybody knows we stayed in our lane.
That's all right.
And we can add it, but I don't suggest waiting for parties to give us suggestions.
Right.
Just say,
Just have to be
PUC is
able
not
to.
the avenue to adjudicate claims.
Or can you come up with something appropriate?
I can just put, that
I agree.
The order
We don't need
is-
to try to get everybody in.
it's solely based on the contract review protocol, nothing
Yeah.
else, something we
Put a notwithstanding.
notwithstanding, this is solely on the contract review protocol.
Okay, with that being said, is there a motion?
Move to approve docket 26-10 with the correction on number 2 to reduce the 5,078,000 to the corrected amount, which would probably be 5,056,000. And then adding your suggested language, AOJ, PUC is not the form to adjudicate these claims.
Thank you, Joe. Second?
Second.
Peter seconds. All in favor, say aye. Aye. Doris? Doris has a very soft eye, but it wasn't aye. Motion passes unanimously. Thank you, GPA.
Thank you.
Thank you, everyone.
Thank you.
Thank you. Thank you all.
Thank you. Next item is GWA docket number 2609, petition to authorize GWA's procurement of wastewater chemicals for island-wide sewer collection system and pump stations. We have a legal counsel report and a proposed order. Anthony.
Thank you, Mr. Chairman. So, GWA's current contract for wastewater chemicals, for GWA's island-wide sewer collection system pump stations, will expire, in October 2026. GWA has to solicit for an award of new contract for these chemicals prior to the expiration of that contract. And, GWA is requesting PUC to authorize GWA to issue a solicitation to procure chemicals for GWA's island-wide sewer collection system and pump stations, and it estimates that this contract may exceed $1 million, which is the review threshold. So, basically, GWA has to obtain the PUC's authorization to issue the solicitation because it's an amount that may exceed the contract review threshold of $1 million. GWA's estimated contract cost in excess of $1 million is reasonable. This is basically a multi-year contract. It's not certain exactly how much wastewater chemicals it will need during the multi-year period, or how much chemicals will actually cost during that period. However, GWA has historically required wastewater chemicals in excess of $1 million. For example, on May 7, 2026, PUC authorized GWA entering into a contract with JMI Edison for the purchasing of dewatering cationic polymer for the Northern District and the Agate Satellite Wastewater Treatment Plants. This was a 5-year contract term. That was estimated to cost up to $1.3 million. Here, this solicitation will be for a multi-year contract, but it will have an even broader scope because it will be for wastewater chemicals for the entire island-wide sewer collection system, inclusive of the pump station. Therefore, the estimated $1 million cost is reasonable. The solicitation is also prudent. GWA states that the current wastewater chemical treatment system has improved the performance of the island-wide wastewater collection system. Further, it's necessary, set forth. Basically, GWA has shown that the wastewater chemicals will prevent corrosion and promote regulatory compliance, reducing the number of sanitary sewer overflows. Hence, the chemicals are necessary. Basically, recommending that the PUC approve GWA's petition to solicit for wastewater chemicals, and I provided an order to that effect. Some good questions.
Thank you, Anthony. Any questions from the commissioners? Any comments from GWA? This is pretty straightforward. Is there a motion?
Motion to approve GWA docket 2609.
Thank you, Pete. Second?
Second.
Joe seconds. All in favor, say aye.
Aye.
The motion carries unanimously. Thank you very much.
Thank you very much.
That was quick.
Still want to do,
Yeah, good night.
that was
are you there?
Coming in.
You looking for this W anything?
Yes, they have a
Oh, the Johnson.
short presentation regarding waste to energy white paper.
Okay. Which is under tab 6.
John?
Hey, good morning. Or good evening, as the case may be.
Good evening for us.
Well, John, we are ready to hear your presentation this evening.
If you are ready, I will get started. I have a colleague, Jerry Leone, who, due to his travel schedule, had a period of time. I'm not sure if he's going to be able to join, but that's okay. I'm going to try to work through this, and I think I can do justice to it.
Okay.
First of all, let me see if I can get a screen share up and running. So to do that, I have to send a sharing request. Now I'm going to try and see if I can get this working. You may see if the not the full screen version, but let's see if I go full screen if this does it for me. All right, so can folks see that full screen okay?
Yeah, and we do have papers in front of us too, John.
Super. You might see a few minor differences here, but I think this should fundamentally cover the same information. My graphics staff decided it needed to be a little more clear in a couple places. So very well. I am going to go ahead and present, and if my colleague shows up, then he may be able to step in. But if not, we're going to run through it. So nice to meet everybody. I guess I'll start with a little bit of an introduction. So my name is John Culbertson. I'm the principal of MSW Consultants. We are a non-engineering management consultant serving jurisdictions, municipalities, cities, counties, islands around the U.S. and a few offshore locations to help optimize waste management systems, recycling, alternative processing, you name it. So in this slide, I've got, I understand trying to do this in maybe about 15 minutes or so I'll be fairly quick, but this slide gives a summary of what we'll be talking about. I might have got a little ahead of myself in terms of my introduction, but this is right in our area of expertise. And it turns out that MSW Consultants has been the PUC's advisor to look over some of the Guam Solid Waste Authority operations and rates and costs over the past number of years. And so we do have some familiarity with some of the challenges and some of the history of what's gone on the island. And so that's been helpful as well. We didn't just come at this cold. But essentially, we are, the point I would make real quickly, we are an entirely independent management consultant. We don't work for technology developers. We don't work for haulers. We don't have an engineering practice so that we're not doing this type of work to lead into engineering work. We are very strongly value our independence and our ability to kind of see the world from our clients' eyes and try to do right by them and help them get good data so that they can make good decisions based on their community values. So I do feel like that's an important distinction for how we think about things. So briefly, the next number of slides I'm going to present, I'll be doing, unfortunately, with maybe not the level of technical depth of knowledge as my colleague Jerry Leone. Jerry Leone is a longtime associate with MSW Consultants. And as shown on this slide, brings a great deal of specific expertise, both within private industry as well as on a consulting basis. And Jerry is actually our alternative energy, organics processing, anaerobics digestion expert and associate that we bring in when this type of project comes up. And so Jerry took the lead on working through the material that I'll be presenting here going forward.
John, I'm on.
Oh, great. Hey, well, perfect timing. So Jerry, if you're on, well, first of all, I'm going to jump back. I'd love you to introduce yourself. And if your hearing and sound is good and you're ready to roll, I'm happy to run the slides for you.
Great, thanks, John. I apologize for the lack of video. I had to move from the location I was at. So I thank you for your time today and want to express our gratitude for this opportunity. So I have been involved in waste for a number of years, and I have a specialty in organic materials. Anaerobic digestion has been something I've been working on for a number of years. You can see the history of my employment for about 40 years. And I have been more recently involved, as John said, with opportunities relating to organic waste management, specifically in US. And previously, you'll see that I was involved with the United Nations and worked with them on a number of organic projects, more recently on the island of Haiti, and had worked with them on a similar opportunity. So we can move to the next slide. Hang on. Okay, sorry. That said, the executive summary you could see here. Sorry, folks. Food waste is something that has been a challenge in many places. It's an untapped, reliable resource in North America, and we have seen quite a bit of development over recent years. The opportunity here is to essentially avoid future landfill development and capitalize on the opportunity to divert materials. I'll continue to tell you that there have been a number of successful AD projects. They are challenging, but to the extent that they're feasible, they are very proven in technology and in operation. I think John had made reference to MSW previously, and in that regard, we had conducted a review of the National Laboratory of the Rockies and their overview of waste to energy there on the island of Guam. Next slide, please. So landfill preservation, as I mentioned, is the key to the equation for this opportunity. Unlike mainland jurisdictions, Guam, of course, cannot easily develop new landfill capacity. And this opportunity would be a great means for avoiding future landfill development and preserving the airspace that you currently have. You can see here that there are some key constraints that we'll need to talk through as time goes on. And as a result, we will need some stakeholder involvement that we'll come back and talk about. John, next slide, please. So relative to the waste to energy proposition that was developed by the National Laboratory of the Rockies, I will tell you that there's some takeaways that are worth noting. Specifically, local feedstocks are limited, as you could see. Small scale waste to energy facilities are steadily growing in demand. These facilities do rely on waste from various opportunities, which might include, as you can see here, wastewater plants, of course, MSW, larger hotels that may generate these types of waste, hospitals and schools. There may be others that may not be feasible, but that will be need to explore further. And the primary value of the utilization lies in waste minimization, meeting diversion targets, and producing locally usable products. Those products would include a biogas and a digestate, which we'll talk about further. Next slide, please. So the best waste to energy pathway that we are recommending as a result of our work in this regard is relative to anaerobic digestion. It's, again, a highly widely used technology in North America and Europe for processing a variety of organic waste materials. The end product, as I mentioned, would be a gas material, biogas. That biogas can be used in a number of ways. The biogas could be used, for example, as an energy source for your existing power plant. There could be a potential that the energy could be used in vehicles, in CNG vehicles, assuming those vehicles would be appropriately let's say, suited for that type of a gas, which is done in a number of locations elsewhere. And there is also an opportunity to use the gas, for example, to make, as I mentioned, electricity, but perhaps not so much in your existing plant, but maybe in another facility. And then lastly, there's an opportunity to upgrade the gas to make it what's called a renewable gas that could be injected into a natural gas pipeline, for example, if in fact that proved to be feasible. So selection of the appropriate technology will need to be looked at carefully. There's a means for doing what's called a wet technology versus dry technology. I won't get into those details right now, but that would need to be investigated further. Next slide, please. So our observations were such that waste to energy across the U.S. is traditionally done via mass burn combustion. You'll see here that there is an opportunity similarly for what's called gasification and pyrolysis. We believe that these types of technologies are constrained largely due to limitations associated with incineration prohibitions on the island. And then I show here lastly that digesters, there's roughly 20 full-scale projects that aren't active, that have been in commercial operation for some time, some of them. And they do, I'll point out, which is a key note here, they do require source separation of organics. So things like cutlery and other contamination would not be applicable or not serve well during or in a project like of this type. Next slide, please. So mass burn development projects are challenging, as you can see here. Facilities require massive capital intensive cost provisions. For Guam, I would submit to you that there are a number of challenges that you could see here. I won't go into them in detail, but I think you might be familiar with many of these. And these would be prohibitive factors that would, in addition to limitations associated with incineration, would need to be considered. Next slide, please. So the benefits to anaerobic digestion, as you could see, is the opportunity to divert 25 to 40% of the municipal solid waste from going to the landfill. Certainly a valuable resource that you've built and one that could be extended considerably with a project of this type. This would, of course, postpone the need for building a future landfill down the road, which could involve siting as well as a fair amount of cost, as you can imagine. I mentioned previously about the end products. In addition to biogas, there would be what's called a digestate, which is essentially a compost material that could be sold and be used for gardening and farming, for example, and mulch. Next slide, please. So what I'd like to submit to you is, in summary, a facility that processes between 200 and 300 tons of source separated materials would very likely extend the landfill from 15 to 20 years, possibly more. And our current best estimates would, at this point, we believe there'd be an opportunity to produce upwards of 750,000 cubic feet per day of high quality biogas. And we also believe that at 73,000 tons a year of diverted material, we believe at $150 a ton, that would project out to be an annual value of $11 million per year in preserved airspace. Next slide, please. I'm going to turn this back over to John.
So super, Jerry. Yeah, thanks a bunch. And again, I think we have undertaken, Jerry's presentation was undertaken as kind of an independent look at that NLR report, looking at different waste energy technologies, and I think you can see that anaerobic digestion jumps to the top in terms of what we have seen, and as we have worked with other municipalities and understanding some of the constraints and market dynamics. But having said that, I would be remiss if we didn't offer just some thoughts about next steps. I do feel like that is kind of our passion and why our firm does what we do, is try to offer some thoughtful paths forward. So I have 4 slides here to conclude in terms of some recommendations as you contemplate the future direction of both waste management and, frankly, some tie into some of the power generation, sustainable materials management. And the first, I think Jerry even already suggested a number of thoughts, but stakeholder engagement is going to be critical. You have not only the governmental agencies or authorities that could be involved in the project, but a wide variety of stakeholders, some very unique, to Guam, with military base, with the federal presence, with U.S. and Guam EPA. But there also could be opportunities across some of the businesses, some ancillary businesses to support this technology. And so engaging stakeholders on a variety of fronts is going to be very important. And so I'm sure you know that, but we do always encourage these types of projects to go forward in a collaborative manner. The second comment that I would make, that I feel pretty good that there is a good foundation to do this, but I'm sure you would do this anyway, but I would reiterate that given that the GPA and the GSWA are responsible, they're enterprises, they're responsible for their rates, they should be maintaining existing financial utility rate models. It would be critical for both of those organizations to probably collaborate to create a foundation for really projecting the overall impact of some sort of anaerobic digestion or other facility on their joint operations. And I think, that is something that I think a lot of firms do. We do that. We've helped the PUC look at GSWA's forecasts. And so those existing rate models are an excellent foundation and could be used to build in probably multiple scenarios so that you have a strong understanding of the financial trade-offs of doing some things. Because some of your, you save landfill space, but there's some fixed costs there. So this facility isn't going to come up in a vacuum and everything else stays the same. It probably is going to have a few changes, especially on the GSWA side. Second comment I'll make is that if you do find conviction to really go forward and looking at AD, you're going to want to revisit waste characterization. So MSW Consultants is a leading national provider of this data. We do waste characterization studies ourselves. We've done them all over the country. We've done them from Alaska to Florida to Rhode Island in all kinds of climates. We've done them on the island of Puerto Rico. I wanted to show this pie chart specifically because it was included in the NLR presentation. And if that is the right data, that is very different from waste we've seen almost anywhere else. It seems that you would want to confirm that data, and certainly any vendors or developers of AD technology are going to want that data so they can validate their processes and fine-tune their design. And I think the final thing I would say is that pie chart shows kind of an island-wide combination. But in our experience, oftentimes when doing a waste characterization study for a specific jurisdiction, you want to segregate residential waste, which has certain characteristics, and then various commercially generated wastes, because there are differences in waste depending on the generator, and those are all details that a technology developer would need and be able to use to fine-tune and optimize their facility. And I think the last thing that we would suggest as you contemplate this process is that there has been a lot of interest in this technology across the U.S. and I'm sure, frankly, across the globe. And given your position, relative to both the Asian continent and the North American continent, we suspect you would learn a lot with a thoughtful request for information, which is just a process that we often help clients develop, which provide very good background and incentive and sort of there really are 2 purposes for a request for information. obviously one is to get info from vendors who might want to come serve you, but frankly, I would argue that another equally important reason to issue a request for information is to document that you are serious about this project and to provide certain key financial and operational and policy background details that telegraph to vendors that you've put good thought into this type of project and that you have a good foundation for them to invest development in this type of project. And so that's I'd be remiss if I didn't offer some best practices from doing this for many years, governmental entities. But with that, we hope we fit into a reasonable time frame. We hope it has been helpful to get kind of a second opinion and a pass about this technology and about the options on Guam. And we certainly can stand by and answer questions as you see fit. But thank you for your attention.
Thank you, John. Thank you, Jerry. It'd be nice to see one of these facilities at some point in time. You could help direct us to go visit one of these at some point?
Yes, absolutely. And Jerry, my thought is there probably are some, maybe even some closer Asian facilities, but certainly on the West Coast in California would be a good location in terms of the nearest location that I know of in North America. But yeah, absolutely. And that is a pretty common thing. And I actually think that the jurisdictions that have gone this route are usually pleased to have interested municipal and other stakeholders come and learn about their system. So I think if that is something you're interested in, I think we could absolutely identify some locations. And Jerry, go ahead.
So John, I can also in the meantime provide a couple of videos that are quite instructive and informative that I think would be a good first start prior to a possible visit.
Okay, that sounds good.
Super, thanks, Jerry.
And I'm just kind of looking at what potentially is digestible, food scraps. Does this include meat and so forth also, along with vegetable and fruit and so forth? Basically all types of food?
It would. There is a fine line, however, to some of the meat types that could be essentially mixed in. We'd want a fairly robust front-end processing system in order for the system to be friendly, if you will, and accommodate compatible with those kinds of waste. The meats tend to have, as you might imagine, bones that come sometimes with the meats, and that's specifically what I'm referring to that we'd want to make sure are handled appropriately. But let's say meat that's otherwise separated from a bone would not be a problem.
Barry, I feel like maybe to put this in context for the commission, so the Guam system, you have a commercial transfer station right now where the predominant tonnage goes and then is transferred out to the landfill, and that obviously has some convenience. But I feel like this is a good point to reiterate this notion of, imagine a garbage truck coming in and dumping out, a residential curbside route, all the stuff people set on their driveway, or maybe a downtown business route where they picked up dumpsters. An AD processing system would need to build in some front-end mechanical separation to open all those bags and free the organic material, and then filter out things like glass and metal and wood. And so you may be familiar, if any of you have been out and visited the transfer station, there's not a whole lot that goes on in a transfer station other than just loading multiple smaller trucks into big trailers for transportation. But this anaerobic digestion facility, in order to get the benefits of this processing, would require some amount of space, some kind of a footprint to put mechanical sorting and separation equipment in order to free and separate the organic fraction that's in the waste. So I think I think Jerry mentioned sending some videos. I would encourage you all to sort of think about your transfer station footprint, and then look at some of these videos and see, you'll get some sense of some of the equipment and pre-processing needs, which is how we typically refer to that front end part of manipulating the waste stream, so that you're going to end up with sort of a dry fraction, which could eventually even have other recovery. It's interesting. We have a couple of firms here in the U.S. that are marketing their front-end recovery ability to pull additional recyclables out in that front-end pre-processing. And I know there's some issues with recycling, but there is a little bit more when we say, oh, anaerobic digestion facility, that's a pretty simplified thing. And I do believe it's important that you understand a little bit about the front-end mechanics in order to enable the digestion of those organic materials.
And paper and cardboard, you mentioned some, and wood some. What does that mean exactly by some?
Jerry, you're muted.
Sorry, John, thank you. I would suggest for the most part, paper and cardboard would be quite compatible. The thought there would be we wouldn't want to overwhelm the digester with more volume of those types of fibers than we would with the materials that are typically quite organic in nature, if that makes sense.
Yeah, and with our waste stream, where evidently we have food waste of about 30% and paper and cardboard is 18, 19%. How does that relate to being able to handle digestion of our paper and cardboard? Would we have to cut down the amount that would be put into this?
I don't necessarily think so. Those are somewhat smaller volumes in the grand scheme of, let's call it a recipe. But there would need to be some certainly careful considerations as part of the operation, as I alluded, to ensure that the appropriate materials are going into the digester and not, let's say, outweighted between non-fibrous versus fibrous.
And you gentlemen are probably aware that we live out here in Typhoon Alley, so we do get quite a lot of yard waste as storms come through. Is this type of system compatible with accepting large volumes of vegetation, green waste?
I wouldn't suggest to you that it would be compatible for large volumes. It goes along the same lines that I mentioned on the recipe. However, there is something to be said for the opportunity to stockpile the material during, let's say, non-typhoon season so that it can be bled into the system over time. There would need to be some space provided for that stockpile, but that is certainly something that we could look into quite a bit.
Yeah, and I think if I could, just because I also live in a hurricane alley in the state of Florida, it is unlikely that technology would ever help accommodate storm debris type quantities. I think, to Jerry's point, the recipe could include some fraction of routinely generated yard waste that you might get maybe from your residential sector or some small number. But I don't think, and Jerry, correct me if I'm wrong, I don't think this anaerobic digestion facility is going to make a meaningful dent in the amount of vegetative waste that is likely generated even on a routine basis in Guam. So Jerry, I would love you to comment.
That's right. Okay. Yeah, that's right, John. My comment was more toward maybe a non-wood material and more like vegetative material. So the wood material could easily get chipped and perhaps better compost, or a better technology would be composting for that material. But to John's point, I was referring more to the green waste that might be generated during a typhoon, whether that's leaves, small amounts of brush, but I don't want to mislead you. The wood would be something that would have to be dealt separately.
Yeah, that's right. I think another recipe question, Jerry, I'd love you to opine on for the group, involves like a biosolids. Is there any opportunity to co-digest potentially, biosolid material from wastewater plants, for example? How would you think about that?
We would need to first take a look at what some of the origin of wastewater is. So industrial plants, of course, are going to produce materials that may not be compatible, and that sludges do tend to cause disruption in digestion. So this is going to all really equate down to that recipe that I mentioned. So there is some opportunity for biosolids, but I wouldn't count on it as this technology to be the solve-all, if you will, for sludge materials, biosolids.
So yeah, Jerry, another question again for the group. Just again providing perspective. I feel like we see a lot of smaller AD plants that might be dealing potentially with like an agricultural farm-based mix that might include like manures and agricultural waste, and that maybe goes to a different type of recipe in using the technology. So I think what I'm hearing you say is you can't really combine AD technology for mixed municipal solid waste where you're separating the organics. Like you've got to either design that recipe or a different facility to handle more of that, maybe that sludge, biosolids, agricultural manure waste. Those aren't something you could ever bring together, right? That's important, that each facility needs to know its feedstock very well.
That's exactly right. Thank you, John.
Okay, super. So yeah, and again, that I think for these reasons, I guess the last comment I didn't put in a slide, but it would be part of that request for information where you would be attempting to really provide excellent data about all of these details on Guam. So I think recalibrating and verifying your own waste characterization, identifying sludges and maybe industrial wastewater sources, because all of those factors would be something that the vendor community would look at. And if there's something that one of them has kind of, hey, this is our business model, that might encourage them, to inquire further. And so that's why really getting a lot of good data specific to Guam as part of any sort of initial foray to investigate with vendors across all the continents would be very important on this to make this the highest chance of success.
I notice also under the digestible, you have the business standard PFAS listed. Is that something that's broken down in a plant like this, PFAS?
I'm sorry, you said peat moss?
No, PFAS. Could you speak to PFAS,
PFAS.
destruction
Yeah,
and
PFAS is an issue. That's the forever chemicals that I was alluding to that could very well be in the sludge. So PFAS could very well disrupt the recipe. So as suggested, that's something we're going to want to take a very close look at on inbound materials. Manure, I would not expect to be an issue in that regard, but sludges and perhaps other materials we would want to definitely take a hard look at and are likely going to be incompatible within the unit.
Yeah, I would share that I feel like I've seen the companies that provide the legacy mass burn combustion services are generally touting the fact that combustion does mostly destroy the PFAS, but that is not the case in anaerobic digestion. Anaerobic digestion is not a technology that's going to remediate PFAS in the feedstock.
And how much does this decrease the waste stream, typically, bulk-wise?
One of the slides I showed had, maybe John could pull that back up. So roughly 100 to 200 tons a day in total. If we did the math and assuming the digester, say, ran at 90%, we would be able to come up with the volume, let's say annually. But for the moment, let's call it about 150 tons a day. Or excuse me, 250 tons a day, if in fact the facility was designed between 200 and 300 tons. And again, there would be a means for maintenance, so we can't assume the unit would be running 100% of the time all year. There would be some off time, downtime, etc. But for the most part, let's just assume that 250 tons would be diverted per day.
And I think to me, that's actually where an actual Guam waste characterization study that spans residentially generated waste, commercially generated waste, if you have any industrial type material, and maybe even looking at even at the sludges for awareness would all actually refine and improve this, this essentially an assumption. So again, that's just another area that could be firmed up much more tightly. Should this, I think that may be a little bit later after looking at some of the finances, the joint finances, but that is definitely an assumption that can be honed in on.
I guess the question I was asking is, how does it decrease the volume of the waste? You have 250 tons coming in, has a certain amount of volume. What do you have by the time the facility digests that?
Yeah, Jerry, does
Well,
anything go back to the landfill? So in other words, if you divert the 250 tons from the landfill, it goes to AD. Does anything out of that 250 tons end up back at the landfill, or are you keeping that 100% out of the landfill?
the hope would be that digestate, which is essentially the fiber and the compost material that's left over, that there would be a beneficial use for that material. If not, that smaller volume, let's call it maybe 10% residual, would probably have to go to the landfill, or it could be land applied in agricultural purposes. So there would be, go ahead, John.
I like kind of worst case scenario. If you diverted, whatever you divert, maybe 10% of that ends up as residue that would possibly go back into the landfill. That's pretty good. Not
Worst
90%
case.
by weight is pretty good.
Worst case.
And Jerry, is it the case that some folks use any of the digestate material like as an alternate daily cover? Is that something you've seen where that material has been able to be it's landfill, but you actually get some beneficial use out of it? Is that a possibility?
Very much so, John. In fact, I worked on a project where the landfill, of course, needed cover for vegetative and final cover purposes. So this material mixed with dirt and topsoil would definitely serve a high value when it comes to displacement of having to buy additional topsoil for covering the landfill.
So yeah, so not knowing exactly your cover technology and strategy, that would be it's a pretty high fraction of that 200, 300 tons that is essentially either out of the landfill or is feathered into the landfill as a cover material, as opposed to as a waste material that needs to be covered. So pretty positive implications on that.
And the gas produced is primarily methane?
Almost 100% methane. There is some carbon dioxide, I shouldn't say that. There is carbon dioxide entrained in the gas. So the methane content would be about 60 to 65% with a little bit of CO2 and possibly a little bit of nitrogen. That gas can be purified, as I mentioned, through a technology, and then that would be pure methane at that point, 99+%.
And that can be used either for some type of vehicle fleet or possibly even power plant, I guess.
That's correct. It could be fed right into your power plant with some retrofitting to your existing equipment.
Mm-hmm.
Jerry, does the gas output, does that vary depending on the recipe, or is that pretty consistent across the different types of digesters with different feedstocks?
John, I would submit it would vary based on volume. I wouldn't expect if the digester was handling 250 tons a day on a pretty steady basis, I wouldn't expect to see much change. But if there was a disruption or less amount of material, then I would expect biogas to decrease.
So, but like I think what I'm asking is if this facility were designed, let's say, to really target all the high food scrap incidents, commercial waste, is that going to have a different gas output than an AD facility that might have been designed for, I don't know, agricultural waste and manure, right? Is the gas output linked to the feedstock, or is it pretty consistent?
To a degree, John. I would tell you for the most part, the organics aren't going to be tremendously different. There may be slightly higher concentrations with, let's say, more pure MSW, but I wouldn't expect between the two to be that much of a difference.
Mm-hmm. So, and I guess the last question I have, when you think about the traditional combustion mass burn waste to energy, I know that frankly we have some clients that have those facilities that they're pretty routine environmental protests about continued air emissions and some of the polluting abilities, some of the heavy metals maybe that people are concerned coming out. Jerry, can you talk a little bit about sort of the emissions pollution differences and trade-offs between anaerobic digestion and traditional combustion mass burn facilities? Like how should we think about pollution from an AD plant?
So you need to consider the AD facility to be closed loop in the sense that everything is happening what's inside of a tank. So there would not be emissions, fugitive emissions from the tank, excuse me, The difference would be if the gas would not be utilized beneficially, then there would be a need to flare the gas. Of course, that would defeat the whole purpose for the development. Well, not entirely, but the biogas would be a very large revenue opportunity, to the extent that there would be some off what I'll call tail gas. There may be a small amount of that associated with purification. If the gas were to be purified, for example, and used as vehicle fuel, not all of it would make it through the treatment train. So there'd be a rather small amount that would need to be flared. But in either case, flaring of gas would be a lot more friendly to the environment than I would tell you some of the emissions associated with mass burn. A mass burn is going to have quite a bit different emission footprint. And I will tell you that anaerobic digestion is very minimal as far as environmental impact.
So like the PFAS going into an AD plant as feedstock, if there's PFAS in there, that's going to either go away as goes with, it's not going to be in the gas, it's going to be in the 10% digestate, and then therefore is going to then proceed potentially back to landfill, or wherever it goes, the PFAS goes out as the digestate, the small residue portion, not as the gas portion.
That's correct, John.
Okay.
Now, forgive us for sort of this question and answer, but I do feel like these are points that sometimes it's easier to get a feel for, in a Q&A type format. So I hope this is helpful to you.
So by and large, an AD plant is a relatively good neighbor to residential areas?
Yes, again, there's no emissions. The noise levels are pretty minor. When you start refining the gas, there is a bit more noise that would be involved with the system, but for the most part, it's just a tank facility with a few moving parts, but nothing that's going to get, I think, the neighbors upset at all.
And
Traffic in and out of the facility. Traffic would probably be the biggest impact.
So Jerry, like given that that Guam already has a commercial transfer station where the trucks are going, if I could wave my magic wand and make things work perfectly, you would at least want the front end processing to be at or near the transfer station so that it's very easy to then open the bags and free the organic material and separate the organic material. I guess in theory, you could also put the digestive tanks, the AD facility near the commercial transfer station, but could you also, if you separated the organics at the transfer station, could you then transfer the organics to a different site where the digester would be? Is that logistically possible?
Very much so, John. A client that I worked with here in the U.S. for the last 2 years is doing just that. They have a depackaging unit in, say, Center City of a large metropolitan area, and they essentially end up with what's called a slurry. The slurry is put in a tank, and the slurry is transported by tanker truck a distance to the offsite digester.
Yeah, and again, I apologize. I don't have the footprint and space availability at the commercial transfer station, but again, just trying to give a picture and some ideas about how this may come together as you're contemplating your forward path.
Hey, Jerry, can I ask one question? You mentioned earlier in the presentation that there was a West Coast facility and you had some facilities in Asia that are doing something similar. Is there, do you have any facilities that are averaging about 150,000 people in population?
We need to do a little data research on that as far as population. I would like to think that there is very likely a facility that would match that population, but it's hard to say where that might be. I'm guessing that's probably not the case in California, but if you'll allow us, we'll look into that closer and see if we can't find a site that matches up with that size.
Appreciate it. Thank you.
Jerry, I would speculate that the AD facilities here on the mainland are probably bigger communities, because it is the nature of our business that the lowest unit cost is best achieved through a higher volume facility. And so consequently, the early stage facilities where they have found the investment and have the volume, that's where we've seen waste AD. So it's probably going to be larger communities that have that installed technology for that reason.
Right.
How does the cost of an anaerobic digester compare to traditional combustion? Cheaper, about the same, more expensive?
I would say a fair bit, somewhat less, only because there's not as many moving parts per se, or as much equipment involved in a mass burn. But there will be some cost differentials, as we mentioned, due to some of the challenges in development on the island.
Are there any communities, here on Guam, we separate trash between renewables and regular trash at the house. Are there any communities that are accepting this organic waste in a separate receptacle to keep it separated from everything else right at the pickup?
Yes, the source separated diversion is definitely very, very much could be a key component of this. I don't think it's an opportunity to avoid some of the front end processing that John mentioned, but there is opportunities for collection of that source separated material separately from MSW. Yes, but obviously we're then talking about infrastructure, transportation, vehicles and such that would need to be looked at. I don't think they'd necessarily have to be retrofit, but we'd want to make sure that the right type of vehicles, whether they're available or not, currently would be part of the equation.
Yeah, I would add to that when it comes to, so first of all, there absolutely are cities, Seattle being a main one, New York City being another example of areas that have added a separate container for their food scraps and green waste. But as Jerry said, that starts to have significant cost implications on the waste management system because of the need for now another set of routes to run the same areas to collect those organics. Either that, or you have to redo all your trucks as dual compartment trucks. It's a collection system increaser, and it is also going to require putting some carts for organics at all of at least on the residential side. It'll be a whole investment in carts for everybody again. And I will share the data. The data is not great on high participation in the cities that have that, at least in terms of food. So there's some debate, in my opinion, in the industry right now as to whether curbside food scraps, separate collection, whether that's a voluntary service that people pay for because they're passionate about it, versus a mandatory service that everybody gets a food waste cart, which tends to not get used or have contamination. So that's not a trivial matter to decide to get into the food scrap organics collection business to feed these facilities. Not saying it can't be done, but that's another round of kind of thought process, stakeholders, and also doing some financial modeling on collection system impacts.
Thank you for that.
I have some
Go ahead,
questions,
Dora.
and it's going back to what Peter just said, because you said 200 to 300 tons of organic material. So that's the material that's already ready to be, quote, digested, correct? On your slide? And you're
Already
talking about.
separated, basically it's separated already.
So my question is, okay, on a typical 1 ton, how much of that is able to be, quote, diverted? 40%, 30%?
So if I can clarify.
I have is, Guam is so small, I don't even know if we do 200 to 300 tons a day in total, and of course,
Yep.
Yeah.
Study.
Yeah. And so going back, my question really is, from your average collection of garbage or waste, how much on average are you able to divert for the AD?
So Jerry, so I think to me, this question, let's do some clarifying because, and I'm actually going to jump down to this waste characterization pie chart. Shows food waste is 30%. So what's not clear in this pie chart is the exact source of that material, but I would assume that is food waste all mixed together in the trash with paper, so this is all mixed. Everything here we think is probably mixed together except for the wastewater sludge and the animal manures in terms of how it's collected. So in other words, things that, yeah, so Jerry, I think my question is, do you recall off the top of your head what the total tons per day is of waste based on the data we had? I can't dredge that up at this time in my mind.
Yeah, and I don't. And again, the data we have is in need of being looked at much more closely and perhaps with additional studies. I do want to point out that the 200 to 300 ton a day is an arbitrary number without knowing what that waste data looks like.
Oh,
I would submit to you that we could certainly scale that down to let's say a 100 to 200 ton facility once we have a better handle on the actual volumes. But this was arbitrary in nature, and obviously if we went to 100 to 200, the benefits wouldn't be as large per se, but they would certainly still be quite valuable in the sense of airspace.
Well, so Jerry, I think we should make it a point to follow up because I know that we have data on the landfill tonnage, the inbound tonnage. We should make it a point to follow up after this presentation so the commission can get their actual, we should be able to put together the inbound material, mixed municipal solid waste into the landfill, and we'll put some actual tons together. And Jerry, thank you for clarifying. I think maybe I was confused. I didn't realize this was generic. We should be able to get the commission kind of the Guam specific assumption. We should do that after this presentation.
That's fair.
Okay. Sorry. Yeah. Good. Yeah. I'm glad you asked that question because I apologize. Jerry, I thought we had done that. So we will do that because we should be able to size this slide to Guam's MSW stream.
Because you did mention Puerto Rico has 1 million, but Puerto Rico is a population of 3 million compared to Guam with a population of 150,000. So the amount of waste that we produce is going to be barely 1/10 of 1% of what they have. So, and that was why I asked that question. And following up also, I thought I saw in an earlier slide, there's only 20 AD facilities right now in the US? Is that correct? I thought I saw a slide that said the number 20. Approximately.
Yes. That's.
Sorry to interrupt. Go ahead.
No, you're fine. That data might be outdated by about a year. I wouldn't expect to be too many more than say 25 at this point, but yes, 20 was a pretty good number based on some of the data I reviewed in the US. And those would be commercial operations of this kind of scale.
Is combustion kind of somewhat falling out of favor and people rotating to this technology now?
Yes, incineration is definitely something that people are frowning more and more on. Nobody wants these things in their backyard. And for that matter, the emission profile from mass combustion is certainly quite a bit different as we discussed.
And honestly, they're ungodly expensive. So if you don't have a very large volume of waste that you're willing to commit for 20 to 30 years, they don't make sense financially. So at the moment, we have had a few existing waste to energy facilities on the mainland have added additional capacity. In fact, we had one in our state of Florida that added another boiler at the cost of $500 million for Palm Beach County, which is a hugely populated area. And you might be interested, this is interesting to me. So the municipality of Anchorage, Alaska, which has limited land for landfill space and its current landfill is going to be closing, is actually making a serious push to build, I think, honestly, one of the first new waste to energy facilities in many a decade. And so if you go to the municipality of Anchorage website, I think there's a link that shows a little bit about, they studied feasibility of traditional combustion starting back in about 2020. And there's some interesting findings. And that is probably one of the few locations where you have a big population, you're landlocked, you have limited landfill capacity, but the volumes are big enough to look at waste to energy. That is not Guam, which is why digestion is more suited as a possible solution for you. And hey, Jerry, I can tell you that call it 120,000 tons a year is going to be the amount of. We will take.
Yeah.
We'll send Anthony an email that has the specific kind of assumptions for the island of Guam after this presentation. I apologize, we don't have that for you on the slides today.
Okay, anything else? Joe? Mike?
Just one other question from my
Mike's
perspective, I'm sorry.
I don't know if you can hear me. I just wanted to ask you, when you've, for communities that use this technology, do they usually experience some pushback from environmental organizations concerned about the impact from the emissions, if there's any, I know that, the gas and the burn can be utilized for revenue producing purposes, but not all of it. And I don't know whether, that's typically part of the process is kind of overcoming some environmental pushback from the communities, or the surrounding communities.
I would tell you that here in the U.S., it's actually the opposite, where the environmental opposition community is favoring these kinds of technologies, because organic waste that goes to a landfill, assuming there's active gas collection, on a good day, only 80% of that gas is going to be captured on average from landfill to landfill. So in a anaerobic digester, 100% of that gas is managed.
And actually, to that same point, one of the other reasons this technology is favored is because if you're already investing to put some front end mechanical and screening equipment to separate the organic material, the firms that do that front end processing oftentimes can pull out some additional scrap metal. Maybe they can get some big pieces of cardboard. Maybe they can even, flip out some, aluminum cans and steel cans. So there's actually also a little bit of incremental built-in recycling, as well as the 100% gas capture. So I think for both of those reasons, I think it's perceived as a more environmentally friendly technology, and I think validly so.
Good, thank you.
Doris, you had
No,
another question?
my question was more, what's GSWA's take? I know this is our initiative, but have we, are they, yes,
We'll be speaking with them about this.
okay.
Yeah, tonight it's reviewing their presentation and basically approving it if we choose to do so, so that we can approach Guam Solid Waste and other stakeholders with this information. And that's what the Guam specific numbers that we will provide.
Anything else? All right, well, thank you very much, John and Jerry. We'll be speaking with you more in the future, and if we could get some Guam-specific numbers in the future to look at, then that'd be great. And other information as maybe video presentations and so forth on this technology.
We will, we'll debrief.
We'll get that to you.
Yeah, we'll put a little care package together to put all these things, Jerry. We'll get all these things maybe on a brief little tech memo with links and a couple of tables. But no, very, very much appreciate this. This is not, I mean, on the one hand, the high level concepts are straightforward, but these details are really important. So, I thank you for your willingness to listen to us talk through, some of the shop talk here on this. We hope it was helpful. And obviously happy to help out. That's the role we serve. So appreciate the opportunity to do so with you.
Thank you very much. Have a good day.
All right. Thank you. Bye.
Thank you, Anthony. That was very nice.
Well, I do want to just applaud for the chairman's initiative for at least having us start to think about this, because I think that's appropriate in our world. But just based on what I've seen, I don't want to be are even big enough to even,
That's possible, it might be too rich for our blood.
yeah.
If it's possible.
But I think these types of initiatives are very appropriate in our role. Yeah, so thank you for that, Mr. Chairman.
You're welcome.
Wait a second.
Would you want to approve it, or did you want to wait for the more specific numbers that we gave you this?
I think we need the Guam specific numbers because,
We'll wait.
you know, yeah. So, yeah, so whatever is the next phase of this presentation, we need to find out, get it on the record, at least we've tried, right?
And then next is update on renewable energy rate sustainability white paper. Anthony,
Yeah, so, yeah. Yeah, so for the rate sustainability, we did get a proposal from Mariana's consulting group, that's on tab 5 of your board book. And basically to look at whether or not, as we get more solar online, we can already see the cost of these 25-year ECAs, which are solar companies. And currently, that's being absorbed through the LEAC, which is currently suffering strain from the war in Iran. Whether or not we keep this with the LEAC, or whether or not we develop a base rate, or we put this into the base rate or somewhere other than this. So that's kind of one of the things that they will be looking at, and then also we'll be looking at. By 2030, we're supposed to be at 50% renewable? Or would it look like
2035.
Or 2035.
But GPA's goal is to be at 50% by 2030.
Okay.
Their self-imposed goal.
Yeah, the other thing they're gonna look at is, well, what are the rates gonna look like if we get to 100%? So,
I don't think anybody's gonna go 100%.
Well, the present law states that they're supposed to go to 100% by 2045. So,
I'm gonna be around to find out.
well, we have a certain responsibility in the community to kind of look ahead, look over the horizon and see what that might mean for rates and so forth. So that's why we're commissioning this to do, is to take a look at how things will lay out as the future unfolds.
the bottom line is, we're estimating that this study will cost between $20,000 to $40,000 at the rates. Here, in contrast, MSW, but all they did is make it present, they're not actually looking at doing a rate study. They were about $6,000.
These guys are
Yeah, but all they did is come up with that slide back, and they've only been at it for the last 30.
I would imagine getting
High
Guam,
overview.
getting the Guam information is gonna, are we gonna pay for that additional?
Possibly, I don't think it'd be very much.
Yeah, I know that part.
we should probably include this since it wasn't included.
Yeah.
Yeah, they might do it for nothing, actually. I had the feeling they were almost a little embarrassed that they didn't have this Guam specific information.
Okay.
I think they probably just do it for us.
But I know that they've been in contact with Home Solid Waste Authority.
Okay.
They send me through emails to the principals. That's how much they're estimating that it will cost. And basically,
And just again to re-summarize, you're saying,
I mean, at the end of the day, even if we go to 100% renewables with the power plants, the power plant still charges for those.
Oh, there's a minimum pay.
Yeah, so, well, that's, what's
So
the,
you get an imbalance there. And then the other thing you have to be concerned
are we talking
about,
about rooftop solar? Or are we talking about,
solar in general, 100% solar.
yeah, but 100% solar from the power plant perspective, with rooftop, that's a certain percentage we're trying to probably drop that, to address that issue, but.
Yeah, we have a financial obligation to pay Guam PUC Power for a minimum amount of power production over the next 25 years.
right,
Right, based on,
So you can't just flip the switch off on that.
And the same way for all future solar plants, you
Yes.
have to buy
That's right.
all that they,
25-year agreement.
yeah.
So we're approaching the 50% number on that avenue now. But the idea is if we were to go to the 100%, how does all this stuff balance out financially? We need to take a deep dive and look into this.
So what is what is
Mariana's consultants.
going to do?
Well, they are going to basically analyze how the LEAC variability will be impacted by higher levels of renewables, okay? They also will take a look at the recent historical time period, basically the last 5 years, because we're almost at 50%, quite there. And the bottom line is, it's going to be a study on the LEAC. The most likely outcome will be a finding that this will substantially increase the LEAC by 2030 and substantially increase it further when we hit 100% renewables.
What will increase substantially, the LEAC?
Yes, because the LEAC is absorbing all the ECA agreements that we have with these solar production facilities, right?
And here everybody's thinking because of solar power will be cheaper, and you're just saying the
Well-
complete opposite.
No. How much solar is the right amount of solar is what we're trying to find out. So, yes, where we've been coming so far has been helpful. But there is a certain point where it may not be helpful. So we want to do a deep look into the data as to how this will unfold as the future goes higher and higher. If it's 100%, Doris, there's several variables here to consider too. Rain season. It's one thing to have solar working with the power plant and they help each other out at a certain level. But if you're just solely reliant on solar, you're going to have a lot of solar panels and a lot of batteries to cover the rainy season. And then the cost goes up significantly. And we don't want to be caught in a spot where we get surprised by this. We want to be looking ahead over the horizon and having an understanding for how all this is going to work together.
And share the findings of the legislature.
That's the whole idea.
It doesn't make economic sense. Okay.
So the amount that we're spending on this study is de minimis compared to the cost that we could incur by finding out the hard way like Hawaii and some other places have. Their rates are double our rates right now because of the path that they went on. And they're starting to reconsider their options at this point. They're starting to look at what we're doing.
So what mistake did Hawaii make? Because, I'm sorry, I'm not familiar.
They bought into renewable too quickly at too high a price. And this is one particular moment where we were pretty lucky to be behind the curve a little bit. We had a better opportunity to pick our moments in time to get better pricing and better results. Which is why we are the low-cost leader in the entire Pacific Ocean.
Do you know what our rooftop solar is today, compared to in terms of ratepayers?
32 or 34 megawatts?
No, in terms of percentage. Right now, we said, the percent of the customers.
Oh, it's about, it's a little over 3,000 rooftops.
Yeah, it only increased slightly, I want to say like 500, 600-ish.
The trend is fewer households probably and more larger commercial applications. So yeah, it hasn't built as many users, but you're starting to get bigger systems up.
More panels.
And many of these systems are starting to incorporate batteries more too. But I think it behooves us to have a certain level of responsibility and forward thinking that we stay ahead of this and take a good solid look at it. And then what we find, we share it with everyone else. That's what this is all about. The other consideration here in the study is whether it's a better idea. Fred and I have talked about this for many years too, and Anthony and I are talking about it now. The LEAC has been doing the solar farms all along because it's somewhat related to helping reduce the amount of fuel we buy. Plus, it expedited the ability to get those contracts going quicker. Because if we had to stop every time we were doing a phase in the solar farms, we would have to do a base rate increase all the time. Now we're up to phase 4 on solar. So it might be worth our while to take a look at whether or not it might be a better idea going forward to put the solar along with the regular traditional power plants in the base rate and take it out of the LEAC. And at that point in time, with more solar in the system and bringing it over to the base rate side of the equation, it's not increasing rates at all, you're just putting it from one side to the other. You take the LEAC and you make it really de minimis. So it's not such a big factor on people's bills going forward. It's not the big factor it's been for so many years where it fluctuates.
All you're doing is just shifting the numbers.
That's
all you're doing.
You're shifting the numbers over to the base rate, but it's out of the LEAC. And the LEAC is just solely fuel. And the fuel is less and less as time goes by. So the LEAC number will become quite a bit less. Oh, we're gonna take a look at it. If we think that's a good idea, then we'll make a decision at a later date.
Is this a study that the PUC is including?
Yeah.
Was it passed on to the utility?
All of our stuff gets.
Well, it's all
passed on
one
to-
way. Like Doris said, it's 6 of one and half a dozen of another.
Yeah. Doesn't matter, all we did was shift the numbers, the bill stays the same.
Speaking of financial reviews.
No, but the potential numbers we save by doing a study like this could be measured in the hundreds and hundreds of millions of dollars.
I'm not sure how.
Oh, geez. You'll see. Let them do the study. Anyway, is there a motion?
I didn't see any motion, I just saw their stuff, I just saw their letter, I didn't see any.
Well, you just,
Well, you want to make a motion to proceed. Just like
proceed on FCG study for the LEAC.
Just like we did last month for the Energy Away, same thing. Is there a second?
Second.
Mike seconds. All in favor, say
Wait,
aye.
I have a
Oh,
question.
Yes, go ahead.
Okay. Where did you get the number 20 to 40?
Oh, that's on page.
That's the number they offered, Mariana's consultant.
Oh, they did, I better check that.
No, it's, page 6, the, one that's got the blue, just before the, last page. It's, below that blue page.
Oh,
Roll
okay.
that.
And that's just an estimate,
All
but.
this takes is one roll down.
Give them your Rolex, you pay them to tell you what time it is.
Good way to put it.
So that's our range, that's a big range.
But, this is actually a rate study. Or, it's a little, it's not a, you know, one of the rules that overview is very specific.
Yeah, this will be a much more definitive in-depth study than the one we had.
Have you ever used Mariana's consultant?
Oh, yeah, we use them, we use them for the LEAC all the time. They're our LEAC consultant. So there's a motion and a second. Doris, are you done with questions?
Yes, thank you, sorry.
All in favor, say aye. Aye, the motion carries unanimously. Next item, fiscal year 2026, third quarter financial review. Doris, any comments?
No, other than our expenses, you know, our move here and,
Do we have enough
double
interest,
the,
do we have enough interest in our CDs to pay for this consulting study?
Just about.
yeah, and, it's really difficult for me, to project, but, at the rate we're going, usually we always budget to zero, and I think we'll end up, depending on how much billing Anthony does, that will be the offset.
Pick up the bill.
Well, now that we've done the last one, or the first one, yeah, that's gonna be a big go.
Okay.
All right.
Because Anthony has only billed $5,600, which is nothing by comparison. Yeah, so I'm hoping you're more than double that, right?
Well, that's only on the stuff I complete.
Yeah, right. But we still have to approve.
That's right.
Yeah. Okay, so anyway, we do have 5 TCDs and we've been doing pretty good with that. I had you prepare a schedule, but it's not quite up to date because we didn't get she didn't get all the information from,
Coast 360.
Coast 360. Yeah, so we've got 5 TCDs, and depending on how we close the year, we might be in a position maybe next year to do one more. We might be, but I want to wait until after we close the fiscal year.
All right.
Any questions?
No. Good job.
Thanks.
We're still salted.
Yeah.
And then do the next item.
No, Anthony.
Research into obtaining Guam benefits for PUC employees. Anthony, we've done any research?
Yes, quite a bit.
Oh, wow, okay.
So, the bottom line is, we, QC staff, we're not employees of government at Guam, okay? We don't have equivalent statutory language, let's say, the University of Guam. We are a public corporation, just like UOG, for example. The UOG statutes say things like, and the employees of UOG will be members, or shall be members of the Guam Retirement Fund. There's language that says that they'll have the same rights and emoluments, whatever, as Guam employees. That would include, for example, Guam healthcare, health insurance. Okay. The PUC has no such equivalent language. In fact, we're supposed to be independent of the executive and the legislative branches, according to our enabling statutes. Now, that said, we could either seek to change the law. The issue we might have here is we exist because of the federal, basically federal law that says that you're a utility and you're going to sell bonds on the bond market, federal bond market, so you have to have an independent rate-making authority to ensure that the rates will cover the cost of the bonds. They don't want the bonds to default. And that's right now since 1936, and such an asset in that. So the feds might question our independence if Guam, the legislature has the ability to mess with things like the case or the PUC staff, whether or not we get health care, whether or not we're on a retirement fund. Now, the only other body that's similar to the PUC is a research corporation of the University of Guam. They are 100% federal funded, and they don't have, just like us, Guam health insurance, nor are they members of the Guam retirement fund. But they say, and I think they offer health insurance, and they have hundreds of people that they're employed that are all working on federal grants, which just gets a federal grant or something. That's the entity that goes and hires and manages and employees pay with those federal funds. So they basically have their own health insurance, separate and apart from Guam. The problem is that we only have 3 employees. That might be tough. I cannot, because I'm a military retiree, so I TRICARE retired, and so I don't want to lose that. So that leaves you with 2. And the other thing that RCAG does, it has a matching program. So if you have a retirement type of like a Roth IRA, you know, some other type of 401k, basically, RCOG will match. It's dependent on whether or not that's allowed by that grant fund that person's employed under, some do, some don't. But they'll match that employee's retirement regimen by a certain percent more, so it's 14% match or something like that. So, those are other alternatives that you could possibly.
That's,
We only do 3%.
Well, maybe it's not 14%, off the top of my head, maybe it's also 5%. But that depends on whether or not the employee has their own, IRA, whatever, they don't, there's no match. So it's not completely guaranteed, but those are some examples of what the agencies do. I could explore things like health insurance. I could also explore, or I could also look into what RCAG really is, or how the matching program does work. And, if you wanted me to research those issues, or, like I said, if you wanted to get us into Guam health insurance and retirement fund, it would take a change to the law.
I don't know if we wanna go that route.
Yeah.
Yeah, then we get bombed out. Yeah, then we're, all of a sudden we're saying we're independent, and then we're coming back.
That's right.
Yeah, so, cross out.
I'll do some research,
But there's no reason, I mean, if benefits were the key, driver here, there's no reason why we couldn't, but besides the medical part, because it's not big enough. I don't know, no, insurance companies are carrying 2 people for like a company, like you have a company size of 5 or 10, for example.
Yeah, I know that they used to allow for singles, but that was state level.
yeah, I think just one insurance company did it.
We'll just do one single.
And didn't the court separate from the health insurance? Because I thought they did on the health insurance. Didn't the
Yes.
courts separate on their own?
but their judicial council authorized that.
And they're doing one self-insured.
No.
No,
They have Calvos, but it's a different.
We procure on our own.
Yeah.
The judiciary is not part of the Guam.
How long is
Health
There's
insurance.
some companies that are
That is a legislative.
self-insured.
Oh, that's a legislative.
No, they are always trying to put the judiciary back in.
Oh,
Yeah, that is a constant battle every budget year.
Yeah, and the reason for that is because for Guam Health Insurance, the more players you have, it brings the cost down because, there'll be less, what happens with health insurance is the more unhealthy you are, and when you have a bigger pool, the numbers help lower the cost of health insurance. So we would actually have to piggyback on somebody without asking, I mean, without,
But I could look into whether or not.
Yeah.
For our employees.
Yeah.
Footprint.
Right.
Not someone who does us.
right.
I mean, that would be that, and if you're doing like, not part of the retirement fund, and there are 401ks that people administer treatment for that office.
Yeah.
And it's just
Number two.
it's like weird, for our company, we're like 5 people, so we don't know what they do, so it's not that difficult. We just have to decide how much we should do. In terms of it's 3 to 5%, and the rest, the employee matches, is on that. So,
We'll look into that.
Okay.
Speak to Frank Campillo, Calvert,
or
for the health
for the health
insurance.
insurance.
Yeah.
Guam is self-insured, Calvo's just administered.
Yeah, correct. They started that with dental first for a couple of years, and then I think they've gone over to medical now too.
I think GTA is doing something.
So in Guam, it's Medicare that administers the dental insurance product, and it's Elbows that does that.
Yeah, but that gives you that medical fund. They pay all the medical bills until they show up.
Yeah.
It's like we're just.
Oh, no, you're talking about about self-insurance. We're not. That's too big a risk.
No, if you wanna do it compliant.
Part of the plan.
Even larger group. And then lastly, FYI, GPA docket number 2603, GPA submission of its LEAC update report from February 28, 2026 to May 31st, 2026. So is this active or is this a running, wish somebody was still here, I wish John Kim was still here, I can ask him this.
The requirement of fair balances.
I think it's as of, because this was July 10th.
Okay, so we were making,
Running totals.
so we were making progress
Yeah.
until Epic Fury really got on board. And then now we're behind the curve again.
As of May 31st,
That's,
I don't know.
that's the lowest under recovery in a long time.
We're heading, by February, depends on whose estimate, Mariana's Consulting is thinking it's gonna be 35.
35,
And GPA was suggesting 28, and, yeah, even with that increase of the 6 cents,
Oh, the under recovery,
by February.
28 million?
Now, we have been as, low as 47, that's the lowest we've always ever gotten.
You mean the highest?
Under highest. And, that was a little uncomfortable.
Yes.
35 is comfortable.
But GPA went to great lengths to make sure that ratepayers had the least amount of impact as possible. Mainly with the liquidated damages.
We've got some other efforts.
The liquidated damages are already used up.
Are we gonna?
How long is the war gonna go on? I have no idea.
How long was that for? That was for 6 months.
Until we bomb the hell out of Iran, it's gonna continue.
Yeah, the Desert Storm veterans like me, we're all retired, so it's gonna protract. 100 hours, that's something we do. I don't know about this generation.
100 hour?
Now it's
We took out Saddam Hussein, 100 hours. So we're all retired now.
Anthony didn't mess around.
The warriors.
Well, it's easier training.
100 hours.
We ran some stuff for nothing, crap.
Actually, Iraq kicked their butt.
Yeah,
Yeah, they won the Iraq.
well, they did mass human, back then they had no technology. Oh, by the way,
Mr. Chairman, motion to adjourn.
Second, all in favor, say aye. Thank you very much.
Start talking about this.
We're analyzing the war.